concept of universal, natural human rights, they go to international organizations and they appeal to the international community to promote their interests and their views of how they should be treated. So it's one of the strangest things in the world to listen to a 15-year-old who is a member of an Amazonian indigenous group that is being displaced from their land so that basically they can burn all the forest and build farms. And she's arguing that they should have the rights to the land and they should have all these different things in terms that would make the founding fathers of the United States shed a little tear, because it sounds like they are being quoted, because she's talking about natural rights. Now, she may or may not have ever read the founding fathers. She's not speaking in English. She's speaking in a local language which someone is translating. But she's using a universal language of rights. Rights not given to her by a polity, but rights derived from her existence as a human person. And that's a big deal. This is one of those things where the Western legacy is so deeply embedded that most people, when seeing it, don't get the inherent contradiction. You're using a justification that derives from the Western cultural tradition to argue in a Western institutional framework built in part on the deliberate exploitation of people like you. And it's a weird thing to see. It's one of those things that as you get more and more informed on these issues, you'll tend to sort of have different ways of watching the news than other people do, but it's weird. The difficulty for us is that when we talk about international law, there's some real basic tensions that remain for us. When we talk about natural versus positive laws, we start running into trouble. Why? Because are there, at a global level, mutually agreeable natural laws that we can derive from our existence as human beings? Now, in the West, we think about natural rights so, well, it's just so embedded. We think about it just so much as a part of daily discourse that we don't think about the fact that this is contested. What is the natural law to someone in an Islamic as opposed to a Christian society? The reality is there's no such thing as an Islamic society. There are hundreds, if not thousands, of different Islamic societies, just like there are hundreds, if not thousands, of Christian societies. There are people in the United States today who, if you switched out the word Allah and inserted the word God, you would not be able to tell the difference between the group here in America who wants to advocate for God's law to become the Constitution and to replace everything else. You can't tell that from the Taliban's argument about how they should live in Afghanistan or Pakistan. And so to these different groups, you might see more commonality between these fringe groups within their religion than you do between themselves and their co-religionists. So you look at these sort of the less than 1% sects in America, and their views are going to be almost completely incompatible with mainstream Christian views. Just like the Taliban is just not compatible with mainstream Islamic views. And we haven't even talked about Sikhs and Jains and Hindus and Shinto religious practice, or Buddhists, or everybody else. I mean, I could keep going for hours and hours and hours looking at all these different views. How do you have natural laws when people have fundamentally different beliefs about what it means to be a person and how the world works? Let's just say that we can agree we could derive natural laws. All right, what are they? What are our natural laws? And let's say that we could make a list. Does it matter that these laws exist if no one enforces them? And where do we draw the lines? What if communal societies, and honestly, we can make a case for the fact that they are at least a significant minority of the world's cultures, if they were deciding, they might argue that there's a natural right to a basic minimal standard of living, a natural right to what we would in the West call gainful employment. That would be anathema in American politics. We would never accept that. But there's enough kind of communal groups out there in the Christian world and in the Islamic world, and there might be enough people that if we took a vote globally of 8 billion people, yeah, it might win. You might actually get the argument that it is a natural right to have gainful employment. In America, that just completely goes against our basic cultural framework. So we have problems here with sort of natural versus positive law and trying to figure out where the boundaries are. We have a universal Declaration of Human Rights. We're going to talk about that later in the course. We have that. We have a universal Declaration of Human Rights. And it's from the United Nations. And it's supposed to reflect all the rights that we have by nature of being a human being. So they're supposed to be natural rights. But they're created by a global organization. But the organization can't enforce them. So are they natural rights? Are they positive rights? Can it be a positive right if there's no sovereign? Is it really law in the way that we want to think of law if there's no sovereign? Because if there's no enforcement, does that mean there's no universality? What role does consent play? If we all agree to follow the law and we go along with it, but nobody enforces it, how exactly does that work? And we're just getting to the surface. I'm using these as examples to show you how much fun we're going to have in discussing in this class. One of the big challenges with international law is it does not lend itself to simple answers because the basic underlying ideas are complicated. So we have some puzzles. We have a lot of puzzles in this class. We're not going to definitively answer any of these puzzles. The basic questions that I'm talking about here, the basic structure here, we will not definitively answer it. There will be no rabbit out of the hat moment for you in this class. We will not sit here and have discussions and talk about questions and talk about gaps, and then magically on the last day, I stand up in front of you, I take my top hat off and pull a rabbit out of it and go, ha ha, the answer. Because this is a social science class. And we don't get equal signs in social science. Even when we do quantitative statistics, we put in an equal sign, but right before that equal sign is a little e. And what that e means is the error term, which is a statistical term for all the crap we don't understand. We give it a number and stick it in there. Because we don't get equal signs. We get lots of different equally valid answers to questions. Now that doesn't mean that every answer is good. You have to have things to go along with it. Trust me, when I'm grading, there will be better and worse answers, and there will be wrong answers. But one of the things that we're going to look at in this class is how international law reflects all of these questions in practice. And what do we do in practice? And we're going to look at these things and look at different contexts. It's a really different world when we look at business. Business has to get things done, and they've got to have certainty, but they also manage risk all the time. There's always the chance that your partner company is going to go out of business. There's always a chance that markets are going to change. There's always a chance that 1,000 things are going to happen, and so you manage risk all the time. And international law changes that risk calculus, but it doesn't eliminate risk. And so in the business universe, this is why we get much better established and much more innovative approaches to international law. In global governance of the environment, I mean, frankly, it's kind of a joke. We have treaties, and they don't do anything. They don't coerce anyone to comply. They're great to go talk about, and we have wonderful international conferences every year where everybody gets together and say, look how awesome we are for talking about global environmental issues. But really all the work that's being done is in either an individual country or in non-governmental groups. One of the things that you want to keep in your mind consistently in this class is that we are discussing contentious, challenging issues. There will be no right answers. There will be wrong answers. There will be no single universal right answer. There are lots of right answers. There are also lots of wrong answers. But What we want to look at is what makes all this tick, what makes it interesting. How can we understand the structure and the framework? The challenge for us is that studying international law raises really big issues in international relations. Theory in international relations questions the value and impact of international law, as was discussed in the previous lecture, and international law is a major area of contention in today's IR. Now, IR informs policymaking. And so when we have international law, which scholars who devote their lives and careers to studying it can't agree on, it leads to conflicting information given to policymakers. Policymakers also face a lot of different complex incentives when dealing with questions of international law. So where we're going to end up and where we're going to kind of navigate through the path we're going to follow in the class is that international law is a matter of significant debate. Theoretical schools see international law very differently. Realism almost always rejects international law as irrelevant. Liberalism sees it as part of a process of institution building, of constraining state behavior, of developing communication. Constructivism sees it as a manifestation of the rule of norms. And there are a whole series of other theories, such as neocolonialism, that look at it as just an extension of Western colonial power. And all of these theories are discussed in international law. All of these theories are considered to have validity. Now, they may not agree with each other, and boy, you get them in the same room at a conference, and it's just a train wreck. But there's no inherent way to distinguish one from as inherently better than the other. We're also challenged because IR separates itself in a way that makes some of these international rules more difficult for us to understand. When we talk about IR, international relations frames the universe in multiple systems. There is an international system, which is the framework in which international actors relate to each other, that is governed by international law in some areas. In other areas, it's a free-for-all. We also have a domestic system in IR, where we look at the framework of politics within states. And we don't agree in the field of international relations about how to separate these systems. We don't even agree as to whether to separate these systems. In my work, I don't separate them. I say that there's a domestic system and an international system, both that have institutions. Those institutions both impact political leaders, and in fact, they impact political leaders interactively. What kind of domestic system you have changes how you behave in the context of an international system that's structured in particular ways. And political leaders will be influenced by both levels. You can't, in my view, separate these two the way we traditionally have in a lot of IR. They interact with each other. And if you try to separate them out, you lose things. Well, so we have a problem then in the fact that when we look at these systems, they're going to impact how we see international law. A quick review of these two systems for the people who may not have had Political Science 3501. The international system is anarchically ordered. That means that there is no central authority. All actors have formal equality. So there's no central authority that can coerce any state. They're all formally equal. Actors are materially unequal. So we don't say that states are equal in some inherent way, but they have a formal legal equality. All states in the international system are possessed of sovereignty. They have freedom of legitimate action within their borders. That means that outsiders can't come in and tell them what to do. The sole exception is the Genocide Convention, which says that we can intervene regardless of what they say. But in all other areas, states can essentially do whatever they like within their borders, and there is no legitimate means of imposing policies on them. Lots of illegitimate ways to do it, but no legitimate ways. Domestic systems are hierarchically ordered with delegated levels of authority and a clear chain of authority. Hierarchically ordered is simple. If I have a problem and want to sue, I can go to a local court, a state court, a federal court. We have a process where authority flows Downward, the president delegates authority, Congress delegates authority, and so on through their various paths. The other thing that's interesting here in domestic systems is the use of force is restricted. Only the state has the right to use force to impose its rules. If I have a contract dispute, I can't simply go shoot my partner. I disagree. I think my partner's interpretation of the contract is wrong, so I'm going to go shoot him. I can't do that. I have to sue. Because within the state, only the state can legitimately use force. Even when the state delegates the use of force to an individual citizen, such as in castle laws. Castle laws are laws that say, if I am in my home and someone comes into my home to commit a crime, I have the right to defend my home. Basically, if someone kicks in my door to steal my television, I can shoot them and kill them. That isn't because I, as an individual person, have a right to kill. It is because the state delegates to me the enforcement of the laws preventing crime. A person who breaks into my house to commit a crime puts themselves in a position in which they can be legitimately shot by a homeowner because they broke the law. If a person comes into my home, sees that I have a gun, turns and runs away, and I rush out to my porch and shoot them while they're running down the sidewalk, I will go to jail. Because once they have moved out of the house, they're no longer a direct threat to me. It's no longer I that have the right to go enforce the law. It's the state's job to enforce the law. So the use of force, even in circumstances where we might think that it's left to the individual, still ultimately the decision about force belongs to the state. The biggest challenge that we have in modern America and in the modern world and in our study of modern things in the world is that globalization is taking place and it impacts everything. The speed and depth of these relationships, it's just they're getting faster and faster. If you go to an online college, you will be with students from all over the world because there are students in Africa who are getting American degrees in our online universities. And you can interact with them. You can discuss back and forth class ideas in an online classroom, even though you're in Carrollton, Georgia, and they're in Abuja, Nigeria. You might actually have a circumstance in which your class has people on 5 continents. All 5 continents have people represented. Problems cross borders as well. Pollution in the United States doesn't just affect the United States, it affects everybody. Pollution in China pretty much affects everybody on the planet. They're the biggest polluter in the world. And it impacts everyone. If you are a country that's downriver, you're impacted by what gets dumped in the river in other countries. In many of these areas, we need international solutions. International solutions are required with increasing frequency. For years, the United States has basically managed the internet in a real quiet way. The United States managed it. Originally, it was just a little non-governmental group, and they ran it. And then the U.S. government basically took over and has been supervising. They haven't actually run the day-to-day operations. It's still the same group called ICANN. But the United States has oversight. The problem today is nobody wants the U.S. to have oversight anymore because we have this whole problem where we coerced a bunch of internet companies into giving us the traffic information and the metadata on everyone, everywhere who uses the internet. And so basically the rest of the world doesn't trust the United States to manage the internet anymore, with good reason. We violated their trust pretty horribly. Not only did the National Security Administration and the U.S. government track every single American's information, every phone call you've ever made, every website you've ever visited was all recorded and communicated to the NSA, where it was analyzed to look for potential people who might have ideas that they didn't like, mostly terrorists, but not entirely. The rest of the world didn't really like that very much. And so we basically have got enormous pressure on the United States in the last several years and especially in the last year and a half since the Edward Snowden revelations. And basically, we need an international solution now. An international solution has to come along because what's worked in the past no longer works. And the Obama administration has agreed to cede control of ICANN to some, at this point, unnamed entity, but the most likely entity is the International Communications Union. Or sorry, International Telecommunications Union, ITU. And that has huge implications. The ITU is part of the UN structure, and so it basically says, very differently from the American attitude toward the internet, that because all countries are sovereign, they should be able to control the internet within their borders if they want to. So international solutions are required with increasing frequency with big consequences. It may very well be that the internet becomes a lot less free. It may not. We don't know. But the most likely scenario is one in which the UN system will give dictators a much greater control over the internet if ICANN is controlled through the UN system. We don't know. Past history shows that failure to cooperate internationally can lead to bad things. Sometimes just lost opportunities for everybody, on other times global hegemonic war that kills hundreds of millions of people. So, well, I shouldn't say that. Even World War II did not directly kill more than 100 million people. But the tens of millions of people that were killed directly in World War II, when you add up the people that were killed indirectly having to do with other things related to World War II, you do top 100 million. So basically, past history shows that the failure to cooperate and work together internationally can be a huge problem. And the quicker and more frequent our interactions become, the more the need for some form of cooperative management to sort of keep things moving smoothly. And this is where global governance plays a big deal, and where international law can play a big deal as well. So what we actually have in practice is an intermestic system. This is one of those really cumbersome international relations words in which we try to combine international and domestic into a really lousy term. But it's the one we got, so we go with intermestic. And we don't really know where the international and domestic lines are drawn in IR. And this leads to hugely divergent views, significant disagreements then over international law. If you don't agree on how all these different elements in the basic understanding of the field come in, when you're looking for a more practical application, such as in law, you're going to have huge problems. And there's no resolution to this debate. There's none. When we look at international law and we look at how these systems relate to each other, we see that domestic legal systems are universal to all within a polity, they're non-voluntary, and they're enforced by hierarchically ordered authorities. International legal systems are voluntary. In a domestic legal system, you comply, or somebody will force you to comply or incarcerate you. In the international legal system, if you don't comply, bad things might happen, but probably not. The commitments you have to make are highly divergent. Some countries are bound by lots of treaties with lots of commitments. Others, not at all. The enforcement is by self-help or by societal pressure. As Ukraine has recently found out, the commitment of the United States to protect its territorial integrity, which was codified in a memorandum when Ukraine gave up its nuclear weapons, it was a piece of paper, and it meant nothing. The United States has done nothing about the Russian invasion and annexation of Crimea, nor is the United States really doing anything serious about the continued Russian actions in eastern Ukraine. Now, again, this is one of those current events that might be completely different in a year, but essentially, self-help is all Ukraine has, because the West essentially is not willing to confront Russia over these things. The United States is currently contemplating an expansion of sanctions. The sanctions currently imposed, basically 60 people in the Russian government have had their international banking privileges revoked, and that's pretty much all that's been done. But they're talking about stronger sanctions, and we'll see. We may or may not see them. It's unclear how much the United States is willing to go and put at risk for the Ukraine. And that means that Ukraine is on its own. And we refer to this in international relations as self-help. And That's a problem if you're the Ukraine and Russia's bigger and stronger than you. Societal pressure can matter, but in a country like Russia where they don't care, if the West says that's a bad Russia, Russia goes, yes, that's right, we're bad in Western terms because you've been screwing us for years and we want to restore ourselves. Well, social pressure doesn't work. Whereas social pressure on some countries will work very powerfully. Social pressure on European Union countries can really be felt in their democratic political systems. The biggest thing that we're going to have to get used to here is international law as a contested concept. And I've kind of talked about this in several different ways throughout this lecture and the previous lecture. The biggest thing that you have to remember is that in international law, we still argue over the basics. There are people who will argue that international law is not really law at all. There are other people who say, sure, that, it's law. We have this piece of paper that says this, but does it really matter? And some will say yes, and some will say no. Is international law natural law to which we place a series of codifications to sort of make it clear to everybody, or is it positive law? And if it's positive law, what's the polity? Where is the legitimacy that positive law is supposed to have coming from? And these are not trivial questions. If there is no enforcer, can it be positive law? And the issue area is going to matter enormously. We ignore humanitarian law all the time. We are ignoring it right now. Over 100,000 people have been butchered by their own government in Syria. The government used chemical weapons twice, probably a third time, we don't know for sure, but for sure twice, in massive breach of the United Nations Charter, of international humanitarian law, of the Chemical Weapons Convention, of the laws of war under the Geneva Conventions, and nothing's happened. In fact, the pressure on the Syrian government has relaxed, has weakened, since they used chemical weapons. So we ignore humanitarian law all the time. Sadly, I could spend the next, pretty much the entire term of the course and 6 months after giving examples where we ignore humanitarian law. In international trade law, it's weird because it's hit and miss. In some areas, states comply really well. In other areas, they don't comply so well. Generally speaking, if your trade organization has an enforcement mechanism, you get more compliance. But the problem is that's not a perfect correlation because sometimes, even organizations that don't have enforcement, the value of the organization is so high that people comply even though there's no coercion whatsoever. So trade law, it's a little harder. It's a little tougher to do. And anyone who's really interested in trade law, if there's any of you who are in this class that are international economic affairs majors, you can come talk to me about it. I will bore you to tears with all the vagaries of international trade law for hours and hours on end. But it's very much a hit and miss. It's one of those where I can show you some aspects where just everybody complies. The General Agreement on Tariffs and Trade, there was no enforcement whatsoever, but nearly everybody, including the U.S., was one of the most frequently targeted states in disputes. We complied. We obeyed the panel's rulings, even though we were under no obligation to do so. Technical treaties are actually widely followed. It's really weird. Technical treaties about international standards, and there are hundreds of these suckers for electronics, for mail services, for international banking. People generally follow technical treaties. So what we're really faced with in this class is a challenge. We're going to start with a very general framework. We're going to just accept the fact that there are not very many agreed upon universals. There are very few universal aspects to it. So every single specific subject that we tackle in this class is going to be controversial, and there's going to be debate over how people see it. And what we're going to look at is, let's take the basic framework concept and let's look at it in different issue areas and see how it's applied. So, easy, right? One of the big things that I encourage anyone in this class to sort of keep in the back of their mind as we go through is that this is ultimately a class that is going to be a lot of fun because international law is so murky. It's fun because we're going to get to look at a lot of different things. Now, it's also going to be frustrating because there are going to be some people in this class that really, really, really want things to be a particular way that they just aren't. But international law will tease you because it looks like they could be. So how can you make the potential that's there in international law a reality? And this will get you every time. When we talk about the UN, the Universal Declaration of Human Rights, you're going to go crazy because it's going to sound so awesome. It has all these rights, and for Americans where we're used to these concepts and we have these different ideas about rights, it's going to sound so perfect. And yet we violate it so often. And the implications of some of the provisions in it start to get kind of complicated. So one of the big challenges we're going to face is pulling all this stuff out. It's not so much peeling back the layers of an onion, it's taking a giant Lego onion, peeling back all the layers, and then finding all the different ways that you could put it back together again to make all the pieces fit. That may be the worst analogy I think I've ever come up with. I'm not entirely sure. But we'll see. I don't know. Hopefully that worked for you guys. But what we're going to see is how all this stuff can go together in different ways. How you can piece together these different ideas and these different elements of international relations, of international law, and of how international law is different than what you're used to. And we're going to try to figure out how to make all that work. So, should be not necessarily easy, but at least for classroom discussion purposes, a great way to have vibrant discussions. As always, here wrapping up, thank you very much for listening. If you have questions on anything, email me, ask me in class, come down to office hours. I'm always happy to talk about these kind of things. So if you have any questions, let me know. Thank you very much, and bye-bye.